now have approximately 4,000 Medicare Advantage plans that all have rights of recovery under the Medicare Secondary Payer Act. We've got over 800 Medicare prescription drug plans with those same rights of recovery, right? And all these different entities that need to be located, proactively reached out to, and verifying and resolving any conditional payment obligations on a claimant by claimant basis. And the danger there is the Part C and Part D plans that are sitting there getting data, understanding where they may have rights of recovery, but not having the ability, like traditional Medicare, to refer that debt to the U.S. Department of Treasury or refer it to U.S. Department of Justice. They really only have one outlet to go seek recovery, right, if no one's coming to them proactively. Medicare and Medicaid sound the same, and a lot of people lump them together and confuse the two programs, but they are two separate and distinct insurance programs, two separate and distinct rights of recovery, two and separate and distinct paths to resolve any sort of liens or rights of recovery. You think about our military members, those of active service, family members, folks who might be treating at VA facilities. That there's an entire different line of recovery for the Department of Veterans Affairs, VA, whether it's VA benefits that are provided at those VA facilities or TRICARE insurance that gets extended to the family members of service members, right? Another thing that, we haven't worried about that historically. It's been all Medicare, but Medicare, Medicaid, military lien reimbursement, those are all traps that are lying in wait for folks who are resolving workers' compensation, no-fault auto and liability claims that are just waiting there to ensnare folks. You know what? An ERISA lien's one of the toughest ones out there to resolve, depending on whether the ERISA lien is truly a self-funded ERISA plan or not. Those are extremely difficult, and it really comes down to the plan language itself in the master plan document to determine and assess, is this plan truly self-funded ERISA, and it's going to be an extremely difficult lien to get negotiated, or does their language not really rise to that same level? And while they might say they're self-funded ERISA, in reality, the language of the plan doesn't allow them to assert those rights. And one of the services that we've rolled out that I'm so proud of, and it's been so popular, is this ERISA plan description and evaluation service that we're providing folks now. There is a big difference between simply processing a lien and truly advocating for our client. And one of the reasons why I launched the law firm back in 2016 is because I saw a need for attorneys in the lien resolution and government benefit area to provide real client advocacy on a case-by-case basis. Because at the end of the day, we are talking about the Medicare Secondary Payer Act, we're talking about the Medicare Act, we're talking about ERISA, we're talking about all these federal statutes that are giving rise to recovery rights for lien holders or federal government agencies. And attorneys providing legal advice to clients, they're really best positioned to get the best results. Because, firms that do this kind of work, they shouldn't just be checking boxes. They need to go and advocate for their client.
Let's talk about Medicare Advantage plans, prescription drug plans, the popularity of these plans, the number of folks that are signing up to be in those programs to receive the Medicare coverage and the prescription coverage from the Part C. I mean, it wasn't that long ago there were only 5 million folks on these plans. Today, over 50% of all Medicare beneficiaries on a plan. So the case law has given it to us, right? They've gotten significantly more aggressive also about going after those liens.
Yeah, and that's why you see a lot of folks who aren't sophisticated about Medicare reimbursement when they go to traditional Medicare to the BCRC. And they're getting a $0 conditional payment letter, and they're thinking, okay, well, Medicare's not asserting a lien. When the reality is that, well, nothing's been submitted through traditional Medicare A and B because there's a Medicare Advantage plan that's been paying all the bills, right? And you have to understand that the zero coming from traditional Medicare is not the end of the story. In fact, that ought to be setting off alarms in your head to say, okay, why? I know that bills have been going to Medicare. Why is this showing a zero? And that should signal Medicare Advantage. For 20 years now, we've been talking about Medicare set-asides, MSAs, in workers' comp, right? And for the longest time, it was because, well, that's what Medicare has talked about. That's what Medicare has shared. That's the policy memos and the work comp MSA reference got in a formal review process through a separate independent contractor for that. But the MSA is the tail end to the mandatory insurer reporting, to the Medicare conditional payments. All three of these stand on their own with respect to comprehensive Medicare compliance. And unless you are addressing all three of those, you're really missing it. So when you have such a focus on the MSA, when you're trying to resolve a workers' comp claim, and you don't have any sort of visibility to the MIR, the specific data that's going to go to Medicare through the ORM or the TPOC reports, and you haven't done your due diligence to go to Medicare CRC on the employer side or the BCRC on the injured worker side, you know, all of that is feeding into what the MSA should be going forward. $3,998 Medicare Advantage plans in 2023 alone. And the number continues to rise like that because these plans are so popular. They offer benefits to plan members that are above and beyond what traditional Medicare A and B offer. And we're only going to continue to see that threshold of 50% grow and increase over time. And as more and more benefits get paid out by these Medicare Advantage plans, they will expect to recover conditional payments. When we talk to folks around the country, whether they're clients of ours, whether they are individuals that work within these Medicare Advantage organizations or within CMS, you know, so often the general public will only react to something that they become aware of that's public knowledge, right? They see a court case get decided. They see a press release about U.S. DOJ settling a lawsuit against a plaintiff personal injury attorney for failure to reimburse for Medicare conditional payments. They see an attorney who may be disbarred because of incorrectly handling MSA proceeds. You know, that public stuff is what really registers, but there needs to be an understanding that there's a whole lot going on underneath the surface that folks generally don't have visibility to. Folks think to hire MSP compliance attorneys takes the most complicated, complex fact pattern where they're in dire straits, right? And we've got a pretty good track record of getting results on those types of cases, but we also have a great program in place that would prevent any of that from ever happening, right? And we highly encourage our clients, engage us earlier on the file. You know, engage us on every file involving a Medicare beneficiary or a Medicaid beneficiary, because engaging us early on allows us the time to interact with the potential lien holder or the Medicare recovery contractor, have those discussions that we need to have, and then have the file prepared, ready for resolution when the parties are ready to resolve the case or claim. Client advocacy. Right. The ability to come on board to represent parties who have a goal of resolving this workers' compensation claim, and they were prevented to do so because of an arbitrary policy within the federal government. And it was our arguments as attorneys representing clients that ultimately convinced and swayed the federal government to rescind that arbitrary policy. And now we have clients on a weekly basis coming to us saying, hey, we've got one of those MSAs that was a counter hire that has prevented us from resolving this workers' compensation claim. Can you help? Can you do what you did from that case with us? And we know the road because we're the ones who created the road in that regard.
Love that.
No one really understands on a claim-by-claim basis the different types of insurance benefits that a claimant may be enrolled in or entitled to. So we introduced this verification of entitlement program. Verification of entitlement, what's that mean to you?
You really have to know what in the world is this individual entitled to? What's the benefit that he or she is receiving before you can take that first step to figure out, all right, what is due? What exactly are the benefits that have been paid, and are they really related to this auto claim or this workers' compensation claim? So, for me, it's a game changer, if you will.
Attorneys that are on a file, no matter whether it's on the defense side or on the plaintiff side, they have so many responsibilities on a case to their client, right? And when we talk about liens, when we talk about government benefits, MSAs, mandatory reporting to Medicare, these are such ancillary issues from the attorney's perspective, but they're really so critical at the end of the day with respect to compliance, right?
This stuff, this Medicare, Medicaid compliance material is so far away from the things that you were doing every day. It really necessitates an expert, right? An individual, a firm, right, away from to really focus on that particular subject matter because it's changing every day.
This whole body of law really is developing in a way that requires attention to detail, experience, understanding these changes, how they affect folks who are actively litigating or trying to resolve a liability claim or a workers' compensation claim. It's not enough to simply register with Medicare as a responsible reporting entity, an RRE, right? You have to go the next step and you have to actually submit your ORM reports, your ongoing responsibility for medicals. You have to submit your TPOC reports, total payment obligations to claimants, right? But even that's not enough. It's not about simply registering as an RRE. It's not about simply going through the motions to push data to Medicare through those two reports. That data has to be accurate. It has to be right. And it has to be consistent, because that's what Medicare is looking for. And for organizations out there who are going through the motions with respect to their MIR, those are the ones that are going to be subject to exposures and penalties from Medicare.
All of us have been around the block here. All of us remember when conditional payments were an afterthought. Today, multiple contractors chasing all times and periods in the life of a claim. It is a different world. So if you're just now entering this, or if you had been doing it 10, 12, 15, 20 years ago, it's a different world altogether today. It is a complete different compliance program and system, and getting more and more aggressive every single day. John, you have daily conversations with folks who are fighting you, right? I don't have to do any of that. Absolutely, that's not a requirement. I don't want to do it. I'm not going to do it.
Yeah. You have folks out there, and this is on both sides of the V, who in a liability case, they say, we don't need to worry about that. That's a non-issue. We're not concerned about this. So for those folks who are resolving liability claims for, something more than a nominal amount, I think you need to beware, because especially on cases involving current Medicare beneficiaries, Medicare is going to have the ICD-10 codes
That's right.
that were involved in the case and that were being resolved via settlement. And the settlement release is going to transfer responsibility for medicals from the primary plan over to the injury victim. So going forward, the injury victim will be looked upon by CMS as the primary payer of future medical care. Now the question is, to what extent does Medicare expect that injury victim to pay out of their settlement proceeds future medical care, as opposed to billing Medicare? And that's a fact-sensitive case-by-case analysis today.
We know, John, right, that if Medicare in a liability case makes a payment that's related to an injury associated with this claim, Medicare considers that a conditional payment. Medicare is going to seek reimbursement of that payment from who? I mean, they have choices, right? It could be the plaintiff lawyer, could be the claimant himself. If they couldn't collect from either of those, could they come back to a defendant, to an insurer, right? And legally, they could. The statute and the case law says that they could. It's that silence, if you will, right? Because every lawyer says, and I'm sure you both have gotten the question, has Medicare ever gone after an attorney for not having done an MSA? And the answer to that is nope, they have not. But what they don't ask is, have they gone after a claimant for not doing an MSA? And the answer to that is yes. Every day they shut that individual's Medicare coverage down because somebody didn't take Medicare's future interest into account. That's the question that seems to be missing, or the part of the discussion that they've never thought about, that it isn't you, the attorney, it's the client, right? That injured individual who's going to suffer the slings and arrows of outrageous fortune. Early on in that process of representing the individual in that claim, you had better ask, is keeping your Medicare important to you? Because if it is, I'd like to introduce you to, right, Jim Anderson. I'd like to introduce you to John Cattie. That's what they do, and they will work with us to make sure that protection is done. So whether or not the plaintiff attorney himself, herself, has to do the work, not necessarily, but at least that early conversation of, if the protection of this benefit is important, you had better take the steps to make sure that it's protected.
Let's talk for a second about the results that we see when we resolve liens. Medicare, Medicaid, private and ERISA, military liens like VA and TRICARE. It's something I'm really proud of.
Me too.
Our firm and the results that we get. Not only a file by file basis, we get great results there, but just historically. Anybody can point to a single file and say, yep, we got an 80% reduction on that Medicare conditional payment, right? But that is our average.
It's where we shine, John. It really is. And I'm so incredibly proud of the team that we've built, the folks, at the firm that day in and day out get to it, attack it, and the results that they get file by file and as a process and as an institution, right? The volume of work that we do, for me, it's just the greatest. I'm so incredibly proud, both at the mandatory reporting or 100% acceptance and no error ever, knock on wood on that, right? To the high numbers on Medicare, Medicaid, VA, TRICARE. I mean, across the board, incredible numbers, right? Just amazing results.
When an organization makes the business decision to outsource lien resolution to Cattie Gonzalez, they know they're going to get the benefit of our years of experience, our results, our processes and procedures, and they know that the liens and the government benefits are going to be handled appropriately, quickly, efficiently, effectively. That allows them to focus on what they do best and what their core competency is. And it's a win-win for everybody.
It's what sets us apart, John, in the entire industry. Nothing like it out there. No one comes close to it. And the detail of these legal opinions, right? To go into the file, facts, issues, claims, defenses, statute, regs, case law. I mean, from a true legal perspective, what does that file really look like? We don't stop at the review of the medical, which is where, the traditional, this really enters the reality of that case. What's really happening on the ground from a legal perspective, and the analysis of each of those components, considering, right, maybe the limited dollars that this thing is settling for because of what you indicated, policy limits, whatever else may be happening on the file. I love it. It's what sets us apart. I mean, there's nothing like it out there. When you think about a conservative way, limited way of just looking at the medical, but it isn't just the medical that's living in this particular situation or file. There are legal circumstances and facts that must be taken into account as well in order to get a real comprehensive, and you've had these legal opinions, gone to federal court. You've had courts literally say, in the body of the opinion, we agree with it, it's reasonable, the analysis correct, it takes Medicare's interest into account.
Anybody can provide a liability MSA allocation at the end of the day, but to truly advocate for the client, to truly minimize what this obligation may be and still protect the parties at the end of the day, demonstrate that they've considered Medicare's future interests. It's really attorneys like us giving legal advice about that issue that allows them to do it.